Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we are talking about driving prohibitions. Cases that should have gone to the Supreme Court of Canada, but didn't. Derek Fraze was convicted of impaired driving. He was sentenced to an $1,800 fine and the mandatory 1-year driving prohibition. He appealed his conviction and had a date set in the future for a hearing of his appeal. At the time that he filed his appeal, he applied to the court for a stay of the driving prohibition, which would allow him to continue to drive pending the outcome of his case. His application for a stay was dismissed, which meant that he had to serve the driving prohibition while he was waiting for a decision on his appeal and while he was waiting even to have the hearing on his appeal. He appealed the decision, rejecting his stay argument, and the Court of Appeal dismissed it, saying they did not have any jurisdiction to hear an appeal from a decision not to grant a stay. He sought leave to appeal from the Supreme Court of Canada, which was ultimately denied. This case raises a very important issue. If a person can't have their hearing in time to have their entire penalty completed, why should they have to serve the consequences of the conviction that they are currently appealing? If the courts are so backlogged that a person is going to serve their entire sentence, and in the context of impaired driving, the most significant portion of the sentence for many people is the absence of the ability to drive, the 1-year driving prohibition. If a court doesn't have the power to review a decision rejecting somebody's application to stay that means that in every circumstance where somebody's convicted of impaired driving, they can't have their appeal heard in a timely fashion, and their application for a stay is rejected, they essentially get all of the consequences that they're trying to avoid by filing the appeal. It's effectively a means to prohibit people from taking appeals of their decisions convicting them of impaired driving offenses. And in my view, it raises important issues about reasonable bail pending the outcome of an appeal. As we know from previous decisions from the Supreme Court of Canada, serving a driving prohibition while your case is pending before the courts, ultimately that time can be deducted from your driving prohibition that you're sentenced to after conviction. But if that time isn't going to be deducted because it's all going to be served, what's the point? And why would people appeal their decisions? We need guidance from the appellate level courts in interpreting provisions in the criminal code related to impaired driving, and people should be encouraged to seek that guidance, particularly with new legislation that hasn't yet been tested in our courts and hasn't yet been tested at the appellate level. This is an important case that raised those issues and could have given the Supreme Court of Canada the opportunity to carve out a pathway to allow appeals to proceed in an efficient and effective manner for all parties involved. Unfortunately, the Supreme Court of Canada missed an opportunity here to make things a little more fair, knowing that the next few years are going to bring about a lot of appeals related to impaired driving cases. And that's an unfortunate misstep on their part that hopefully will be corrected in another case. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting these videos together. Please like, subscribe, and share with your friends.